Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Sydney Osmar.
And I'm James Macfarlane.
Welcome to Hull on Estates. You are listening to episode number 704. Hi, James. How are you doing today?
Hi, Sydney. I'm great. How are you?
I'm good, thanks. So for our listeners, we thought today, James recently blogged about a new decision out of the British Columbia Supreme Court dealing with gender discrimination and setting aside a will. And we thought that might be an interesting topic on a gloomy Friday morning. So James, how about you tell us a little bit about that decision, Lamb and Lamb Estate?
Yeah, so this was a recent BC case. It's called Lamb v. Law Estate. And in this case, the plaintiff sought to vary her mother's will. So the main point of law in this case that we're going to be looking at is Section 60 of BC's Wills, Estates, and Succession Act. And what that says is that a court may vary a will if the testator does not make adequate provision for the proper maintenance and support of the spouse or children, and that the court may make an order that is just and equitable in the circumstances. So in the Lamb case, the plaintiff daughter had received about $630,000 total via inter vivos gifts and her mother's will, while the respondent son, who the mother favored, had received gifts totaling more than $2.2 million. So the daughter offered evidence that her mother throughout her life always preferred sons over daughters and had an entrenched belief that sons were entitled to most, if not all, of the parents' estates. The court, in their analysis, they found that the daughter's evidence on this point was credible and that the mother's biases definitely influenced her estate plan. Meanwhile, the court also accepted evidence that both the son and the daughter were very dedicated, helpful, and dutiful to their mother in her later years. But in the end, the court decided that the mother's estate plan was not acceptable by contemporary societal standards. And because of that, it was not adequate, just, or equitable. So accordingly, used their powers under 60 of the Act to vary the mother's will, which increased the daughter's share of a property owned by the estate from 50% to 85%. So even though the daughter was successful in this one, the court did make note that this result paled in comparison to all of the value of the gifts and benefits that the son had received from the mother, and that nevertheless the daughter was successful on this one, even if the change was quite small relatively.
That's right. Well, thank you, James, for that summary. And
No problem.
it's a very interesting case, and it's an interesting set of facts. And I thought it might be helpful for our listeners if we talk a little bit about the legislative framework in BC and some of the decisions that have come out over there and the differences here in Ontario, because it is quite a different system. Things look a little bit different over here, which we'll get into in a moment. But in having this case come across, I was looking into it a little bit more, and there's actually quite a few cases in BC that have been brought under Section 62 vary wills for many different reasons. And but on the point of for an adult child where there may have been discriminatory reasons, or even if it wasn't discriminatory reasons to have cut the person out of the will or give them less or more, the case law has set out 6 different factors that the judge will look at and consider in determining whether or not a testator has a moral duty to provide for their adult independent children. And some of those factors were contribution and expectation. So any contributions the claimant may have made to the testator's actual accumulation of their wealth, which would also found potential equitable claims like unjust enrichment and quantum merit claims. The court will also look to misconduct or poor character. And this is actually also in the legislation. So Section 63B of the WESA sets out that the court can refuse to vary a will if the person's character or conduct disentitles them from the relief. And the case law has said that the conduct must be relatively severe to justify disinheritance. The courts will also look at estrangement and neglect, and they'll consider whether the estrangement is actually the fault of the testator. Gifts and benefits made during lifetime. So if a child or spouse or a beneficiary actually received a lot during lifetime, it might justify a lower inheritance in the will. Unequal treatment of children. The courts did note that it's not necessarily giving rise to a moral claim if one child is preferred over the other, depending on the reasons for doing so. And then, which brings us to the final factor that they'll consider, which is actually the testator's reasons for disinheritance. And again, this is in the legislation. So Section 62 of the Act permits the court to accept evidence of the testator's reasons for making or not making certain dispositions in the will. And in weighing that evidence, the court is directed to have regard to all of the surrounding circumstances that could reasonably support an inference about the accuracy or inaccuracy of the evidence regarding the testator's reasons. So that framework does look a lot different in Ontario. Here in Ontario, generally, the courts have given more deference to testamentary freedom. We don't have a similar legislative framework like Section 60 of the Wills, Estates and Succession Act out in BC. The closest thing we have here would be Part 5 of the Succession Law Reform Act, which sets out the statutory provisions where a testator's power to do what he or she wishes with their assets on death can be restricted by the court. And it's specifically where the testator hasn't made adequate provision for the proper support of his or her dependents. And so to be successful in that type of claim under the SLRA, the applicant actually has to satisfy the court that they come within the list of persons who could qualify as a dependent. So people like your spouse, your parent, your child, or your sibling. And you also have to show the court that the deceased had or was providing support to you, or they had a legal obligation to provide support immediately prior to their death, and that on their death they failed to make adequate provision for you. And then in that framework, there is room for consideration of moral obligations, which that actually comes from a Supreme Court of Canada decision, Tatterin, which has been adopted in Ontario, because Tatterin came out of BC as well. But in Ontario, we have a decision, Cummings and Cummings, which is it recognized that a testator's moral obligations is relevant to the dependent support analysis here. But again, it's within that framework of dependent support, not an independent adult child, for example, would not likely have success under that framework to vary the will, so to speak, and get support ordered. Now, the other aspect of this, because we're limited within the dependent support framework in Ontario, there is the public policy doctrine, which for us in Ontario, the leading decision is Spence and BMO Trust Company, which was a 2016 decision out of the Ontario Court of Appeal. James, do you want to give us a little brief background on what that decision was about, some of the facts and things that went on there?
Yeah, absolutely. So this was a 2015 case, Spence v. BMO Trust Company, from the Ontario Superior Court. In this case, the applicant sought to set aside her father's will on the basis that it was void for public policy, that it had a discriminatory intent. So just in terms of factual background, the applicant and her father had a very close relationship up until about 2002. And then in 2002, the applicant told her father that she was pregnant, but that the father of her child was of a different race. So for the next 11 years of the deceased father's life, from revealing that news in 2002 up until his death in 2013. He refused to return his daughter's phone calls and refused to have anything to do with his grandson. Meanwhile, the father had another daughter who lived in the United Kingdom, but he had no relationship with that other daughter. Despite that, in his last will, he disinherited the first daughter I mentioned with the child of another race. And his reasons for that were that she had no communication with him for several years and had shown no interest in him as a father. So that's what he said. And he distributed his whole estate to his other daughter, who he had no relationship with. But the difference was that that other daughter had two children who were all of the same race. So the applicant, the disinherited daughter, in her application, she had a supporting affidavit who is a friend of the deceased, who deposed that the deceased told her on several occasions that he had disinherited his daughter because the father of her son was of a different race. Something notable about this case was that the daughter who was benefited, she was properly served but didn't appear or didn't take part in the proceeding at all. So in the end, the court decided that the will should be completely set aside because it was contrary to public policy. They commented that while the will itself did not, on its face, offend public policy, the court looked at the extrinsic evidence and established that the father's reason for disinheriting his daughter was based on a clearly stated racist principle, which was clear through the ample affidavit evidence. The court thought that it offended public policy, that the other daughter should receive the entire estate simply because her children were of the same race. And when the will was set aside, of course, pursuant to the SLRA, there was a resulting intestacy, and the father's estate was divided equally between the two daughters. So that was a Spence case.
Well, thanks, James. So that's a great summary of the trial court decision. But you're exactly right. In the underlying decision, the judge did ultimately find that the racist motives offended public policy, and the will was set aside. And that decision then went on to be appealed, and in 2016 it went up to the Ontario Court of Appeal, and it was appealed on two grounds. So the first one, and you mentioned it in your summary, James, extrinsic evidence. So it looked at when is extrinsic evidence admissible in the context of a will challenge, and the second ground was when should a will be set aside if it does in fact offend public policy. And so in the Ontario Court of Appeal decision of BMO and Spence, the court for the extrinsic evidence piece, it looked to the Rondell and Robinson decision also out of the Court of Appeal and concluded that extrinsic evidence of a testator's intentions is not admissible when the testator's will is clear and unambiguous on its face. And secondly, on the second question, the court held that wills being inherently private documents, the court lacks the jurisdiction to look behind the testamentary instrument if the document is silent about the testator's motives for a gift or for not making a gift. So in other words, the will can't be set aside if on its face, it's not discriminatory, and the court can't actually look behind and accept evidence like, for example, that the friend's affidavit that set out the instances where they heard the racially motivated comments and things like that. So the Ontario Court of Appeal said that's actually not admissible, and on its face, the will itself isn't, making any racial or otherwise discriminatory commentary or dispositions, and so they ended up not setting aside the will and overturned the lower court decision, and that remains our leading decision in Ontario today. However, so that the day that the BMO and Spence decision was released from the Ontario Court of Appeal, there was also the Neuberger decision, which was released. And there's been some commentary in the Estates Bar and some articles written about some of what may be contradictory commentary in the two decisions. One being, so in Neuberger, there was some commentary from the court that looked at and classified wills as public in nature, versus in BMO and Spence, there was a lot of commentary on the inherently private nature of the wills. And in Neuberger, the court talked about how wills are actually more than private documents, and that once they're probated, they speak to society at large. Other commentators have also questioned the extrinsic evidence piece in that part of the decision in BMO and Spence. So the general rule is that evidence is it's admissible when it's relevant to a legal issue, and no exclusionary rule of law or policy applies. So some have argued that, motive is relevant to the public policy doctrine, and that the rule in Rondell and Robinson applies to evidence of intention and not to evidence of motive, such that the exclusionary rule in Rondell and Robinson wouldn't apply, and that evidence for the purpose of public policy will challenges, evidence of motive may actually be admissible. I haven't seen a decision to actually make that argument or clarify that point. So it'll be interesting to see, if these types of arguments make their way up into the court system and how this area may evolve. But for now, we have a vastly different landscape for will challenges on the, comparing from the BC legislative framework and case law and what we have here in Ontario. But I think that will conclude our podcast for today. James, thank you very much for your helpful summaries, and we hope you all have a great weekend and enjoyed listening. Thank you so much, and take care.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.